Professor Chris McCrudden. Chris is Professor of Human Rights and Equality Law at Queen's University and William W. Cook Global Law Professor at the University of Michigan Law School. Until 2011, he was Professor of Human Rights Law at the University of Oxford. He is also a practicing barrister at Blackstone Chambers in London, and he is, and I know this because Evelyn told me, a trusted and wise counsel to the Equality Commission. So, welcome please, Professor Chris McCrudden.
Well, thank you, Mark, for that kind introduction, even if it was indirect. It's often said in equality circles that the devil is in the detail. But today I want to prefer a different truism, as it were, that we shouldn't miss the forest for the trees. That is, that we need to take care, in other words, not to miss the big picture by focusing too much on the detail. So my talk today is focused on the big picture of equality law in Northern Ireland. It's focused on the law rather than the underlying problems of inequality and discrimination that the law is attempting to address. So let me start with the past. I'm afraid I'm old enough to remember the origins of equality law in Northern Ireland in the 1970s, and much of what I'm going to be saying is a mere footnote to Evelyn's excellent introduction. Although the old Government of Ireland Act 1920 had applied non-discrimination obligations to Stormont, and although there had been valiant attempts to secure reforms from the 1920s through to the early 1960s, it was the civil rights movement, as Evelyn said, of the late 1960s that was the critical catalyst, leading to the first tentative anti-discrimination steps in the early 1970s. The anti-discrimination provisions in the Northern Ireland Constitution Act 1973, addressing discrimination by public authorities, and the Fair Employment Act 76 followed the collapse of Stormont. Both were, of course, focused on challenging religious belief and political opinion discrimination only, and both originated in Westminster. As the situation on the streets deteriorated and the troubles began in earnest, one of the critical questions to emerge was whether Northern Ireland was reformable. To put it crudely, if it was reformable, then there was hope that politics would work. In that debate, the success or otherwise of government initiatives to address discrimination and inequality occupied a central role. Anti-discrimination law thus took on an important political and indeed constitutional function. By the late 1970s and the early 1980s, the challenges of securing fair employment, in particular, became tangled up in the early beginnings of the peace process. The 1976 legislation, to put it mildly, was not a success. The predominantly voluntary approach to securing compliance that the legislation encouraged and the Fair Employment Agency at the time adopted failed miserably. Movement on reform of the fair employment legislation thus came to be seen inside and outside government as a central element in the developing matrix of what came to be known as confidence-building measures. That is, those measures that were intended to demonstrate that the British government could be trusted to reform the Northern Ireland state, and thus encourage the Republican movement in particular to take the political route. So extraordinary measures and effects came to be focused on that problem, not solely by people outside the room, but by people inside this room as well. Not surprisingly, both Irish America and the Irish government became deeply involved. The McBride principles, modelled on the Sullivan principles that brought American economic investment to bear on apartheid in South Africa, provided an additional incentive for the British government to keep its focus on reforming fair employment legislation in Northern Ireland. The Standing Advisory Commission on Human Rights eventually produced a blueprint for reform in 1988, leading to a series of measures: the 1989 fair employment legislation, the establishment of the Fair Employment Commission to replace the agency, the adoption of a sophisticated regulatory regime that remains far more advanced than in the rest of the UK, and the effective enforcement of that legislation. This in turn led to a significant set of changes in the composition of the Northern Ireland labour market that we see today. It's sometimes assumed by external observers that these changes in the composition of the labour market resulted from the Belfast Good Friday Agreement, but it's the other way around. The fact that fair employment legislation was seen as making significant inroads into what was seen previously as an impossible barrier to political and economic progress provided significant support for radical reformers to argue that the state was indeed reformable. That was one lesson. The other lesson was that legal enforcement worked. We are perhaps too often willing to assume that government regulation always fails. Fair employment legislation challenges that lazy assumption. Now, it won't have escaped your attention that I focused solely on religio-political inequalities up to this point. The reason's quite simple. Although equal pay and sex discrimination legislation arrived in Northern Ireland in 1970 and 1976, respectively, their origins were quite different from the fair employment legislation and derived partly from the local campaign by the women's rights movement to ensure that Northern Ireland should mirror the legislative reforms that were occurring in Britain. More significant, I think, was the fact of the UK's membership of the then EEC. The increasing role that Europe played in developing sex discrimination legislation as part of the panoply of member state social obligations meant that from 1975 and the first Equal Pay Directive, Northern Ireland no longer had any option but to bring sex discrimination legislation into Northern Ireland law. Incidentally, the fact that it took over 20 years for a race relations order to be introduced in Northern Ireland that was equivalent to the 1976 Race Relations Act in Britain tends to bear this out. So though substantially external in origin, once they arrived, however, sex discrimination legislation took on a significantly Northern Ireland tinge. This was because the 1976 Sex Discrimination Order had established a separate Northern Ireland Equal Opportunities Commission. Perhaps paradoxically, the more limited political salience of sex discrimination enabled the EOC to become more radical, and that was used, I have to say, pretty mercilessly as a stick with which to beat the Fair Employment Agency. Throughout the 1970s and 1980s, the voluntarist Fair Employment Agency looked distinctly threadbare in comparison. There was a famous headline over a piece by David McKittrick comparing the two commissions, which read something like, if I remember correctly, Equal Opportunities Commission wins respect by enforcing the law. Quite. Turning now to the present. The 1998 Good Friday Belfast Agreement remains the standard against which the extent of formal protection of human rights, including equality in Northern Ireland, is now measured, as well as one of the key legally binding international agreements applying to Northern Ireland and the area. The negotiations leading up to the 1998 agreement and the agreement itself marked a turning point in many ways, but particularly for the development of equality law in Northern Ireland. Several of the proposals developed in the Partnership for Equality White Paper, which was developed in parallel to and in the shadow of the negotiations, were folded into the agreement. In particular, the Equal Opportunities Commission and the Fair Employment Commission were merged to become the new Equality Commission. The public sector equality duty, proposed and developed by civil society in Northern Ireland well in advance of the equivalent in GB, and then promoted by the commissions and SACR, featured as a central element in the agreement. New fair employment legislation addressing the gaps in the 1989 legislation and extending into goods and services was woven into the agreement also. The establishment of a committee to reform policing was announced, leading to the Patent Commission, the introduction of the quota provisions, and the resulting substantial changes in the composition of the police force. The European Convention on Human Rights, including Article 14, its anti-discrimination provision, was to be incorporated into the law of Northern Ireland, providing domestic remedies for the first time. New institutions were agreed to, including the Northern Ireland Human Rights Commission, and the new commission was to report on the scope for establishing a Northern Ireland-specific Bill of Rights, additional to the convention, including potential reforms to the anti-discrimination obligations applying in the public sector. So the agreement, of course, did not directly create binding legal obligations in the law of Northern Ireland. It was an international agreement. The bulk of the UK's commitments to the agreement were implemented by way of the Northern Ireland Act, supplemented by more specific pieces of legislation applying, such as the Fair Employment and Treatment Order. Other commitments were partly implemented in legislation applying to the UK as a whole, in particular, the Human Rights Act, 1998. European Union law also provided an important and gradually expanding underpinning until the UK left the European Union. The combination of domestic Northern Ireland equality provisions, EU law, and the Human Rights Act has resulted in a somewhat messy but nevertheless powerful package advocating and advancing equality and addressing unfair discrimination. A set of provisions that in combination easily matches the best global standards. I'll turn in a moment to consider the limitations of the practice, which there are. But focusing on the detail of the agreement risks obscuring the bigger picture. With the advent of the agreement, the role of anti-discrimination law in Northern Ireland changed significantly. For the first time, equality law became the mechanism for a new, more inclusive constitutional vision. To explain why that's so significant, we need to see what was going on in the other parts of the agreement, in particular the aspects of the agreement that established power sharing at the political level. It's now often remarked that the agreement was essentially a consociational bargain, one which adopted the understanding that a profoundly divided society required both parts of the divide, as it was seen at the time, to share government responsibility. Overcoming division, in other words, required the recognition of that division. But to view the agreement as a whole as simply a sectarian carve-up profoundly misunderstands the role of the agreement, the part of the agreement that brought equality and human rights into the equation. That part of the agreement provided exactly what the other parts did not: a vision of a future in which the diversity of a new Northern Ireland would be recognised and embraced, one which transcended the two communities' narrative. For the first time, equality law in Northern Ireland did not focus only on the religio-political and gender divides, and instead identified a wholly new set of groups that were to be protected and respected as well. And that can be seen best in the wide range of protected groups listed in that part of the agreement, and in the public sector equality duty provisions that followed the agreement. That wasn't accidental, that was entirely intentional. The agreement made this broad-based, inclusive understanding of equality a constitutional issue in a way that it had not been before. And it embedded that understanding of equality within a human rights narrative. A narrative that, again, transcended Northern Ireland and appealed to universal values. There were tensions, of course, and they became apparent in the implementation of the agreement and in the enforcement of the package of equality provisions. How was the vision of a desectarianized future to be reconciled with the needs of a consociational present? How far would the radically divided system of primary and secondary education be impacted by equality requirements, while still retaining its substantially religious underpinnings? How was the newly recognized catalogue of human rights protections to be reconciled with the requirements of equality law if and when they clashed? How would the different grounds of equality protection be treated if and when they were in tension with each other? These and other issues are the stuff of broad-based anti-discrimination law. And in the period between the conclusion of the 1998 agreement and, let's say, 2016, just to pluck that out of the air, enforcing the law and reconciling clashing values took place in a context that, in retrospect, seems almost utopian. although it didn't seem like it at the time. No doubt. The European Union connection played an important role during this period in 4 particular respects. First, the fact that both Ireland and the UK were member states meant that EU equality law provided a common standard for all 3 jurisdictions, reducing the potential for East-West versus North-South competition. Second, Northern Ireland's equality law experience became a net asset and was drawn on in other European states, connecting Northern Ireland much more than before to the European mainstream. Third, the 1998 agreement's understanding of equality law as presenting an alternative vision was constantly refreshed by European thinking. Fourth, Europe's common citizenship reduced the pressure to identify as Irish or British, reducing in turn some of the tensions that spilled over into religious and political discrimination in the past. Now, I'll turn to the impact of Brexit in a moment, but it's worth noting that, Brexit aside, a problem that predated Brexit confronts us still: how to reform equality law to make it even more comprehensive and more effective in practice. And there are clear problems. The public sector equality duty is not working as envisaged. Public bodies in the main interpret the duty as engaged only in the context of relatively low-level decision-making. And even then, there's a heavy emphasis on box-ticking rather than substantive engagement with the issues. Civil society, which was envisaged as playing a major role in working with public bodies and implementing the duty, is underfunded and often overwhelmed. The PSNI 50-50 quota provisions that had applied up to March 2011 and had proven a success in substantially shifting the composition of the police has been abolished, and there's concern that with no effective replacement, there will be backsliding. There are significant gaps in the coverage of the legislation, notably the absence of any prohibition of age discrimination in the provision of goods, facilities, and services. Since the early 2000s, the Commission, as Evelyn has said, has urged reform to address some of these problems, in particular through the introduction of a Single Equality Act. However, except where Westminster was motivated to act, or EU law applied, action was seldom taken to address these issues by the Northern Ireland Assembly. The one exception was the legislation that Evelyn mentioned, reforming the teachers' exception in the fair employment legislation, passed in the dying days of the Assembly this year. And that was a private member's initiative. It's sobering to recall, if we're talking about equality law reform, that since the 1998 agreement, not one single piece of equality law was implemented in Northern Ireland as a result of Assembly legislation initiated by the executive. That's the context. All legislation implementing the EU equality directives, for example, was enacted by various secretaries of state for Northern Ireland when the Assembly was suspended. In some respects, then, the human rights position improved after 2016, resulting from the de facto suspension of the Northern Ireland Assembly. The issue of abortion law reform, in particular providing for lawful terminations in a much wider set of circumstances than previously, and the issue of same-sex marriage, both equality issues, had for several years been stalled in the Assembly, largely because the Democratic Unionist Party took advantage of the petition of concern. Neither same-sex marriage nor abortion law reform had ever secured the required supermajority in the Assembly. So, when the Assembly ceased to operate, the opportunity was taken, rightly, by civil society groups in Northern Ireland to lobby the UK Parliament to legislate on both issues, even though they were both devolved matters, thus setting a precedent of sorts for Westminster to legislate in areas of equality, even when they were devolved and were indeed significantly contested in Northern Ireland. But apart from these exceptions, Westminster failed to act more broadly. So, as I've said, there is a significant problem here. How to progress the equality agenda, building on what's been achieved. And this will continue to be a significant issue if and when the Assembly is restored. In particular, whether the petition of concern should apply to equality legislation now demands serious consideration. But in the immediate future, the problem we're confronted with now is not primarily how to make things better, unfortunately, but how to ensure that the gains already made are not fatally undermined. Civil society and the commissions have, from before the 2016 Brexit referendum, been concerned by the impact that the UK's exit from the EU would have on the 1998 agreement's equality commitments. These concerns have been taken up by some of the political parties and was recognised in the negotiations resulting in the EU-UK withdrawal agreement, leading to the famous Article 2 of the Northern Ireland Protocol, promising no diminution of the 1998 agreement rights in Northern Ireland resulting from Brexit. In addition, the bulk of EU law binding on the UK up to the end of the transition period became what's called retained EU law in the UK, meaning that it continued to be given effect in domestic law and practice. Much of this underpinned 1998 agreement protected rights. So as a result of these various provisions, the retention of retained EU law and Article 2 of the protocol implemented in UK law, a rough modus vivendi appeared to be developing up to 2020 rather, which meant that existing equality rights in Northern Ireland appeared to be substantially protected, and a modest degree of future dynamic alignment in equality protections between Northern Ireland and the EU was also achieved. At that time, too, there was little, and we're talking now 2020, there was little reason to suppose that there would be any significant rolling back of GB equality law. Several developments since 2020 now threaten this modus vivendi. In 2022, the UK published a new Bill of Rights bill to repeal and replace the Human Rights Act 1998. The bill amounts to a fundamental change in the balancing between human rights protections and executive power. And remember that part of the package of Northern Ireland equality law is contained in the Human Rights Act. Repealing that act and replacing it with the proposed Bill of Rights would significantly weaken the ability of people in Northern Ireland to seek effective redress for discrimination by public bodies, raising potential problems under the European Convention on Human Rights, of course, but also under the protocol, as well as being likely to undermine aspects of the 1998 agreement itself. It takes some legislation to breach 3 international agreements all at the same time. After the change of Prime Minister in early September 2022, the Bill of Rights proposal appeared to have been dropped from the legislative timetable. But now, with the return of Dominic Raab in the Sunak cabinet, it looks like this bill will return, and with it the problems I've identified. In 2022, the UK government has also pursued a range of measures which have been seen as representing significant erosions of other rights in Northern Ireland: the provisions of the Nationality and Borders Act, the Elections Act. But the Northern Ireland Protocol Bill poses the greatest threat. Although ostensibly directed at the issues of trade and customs, the ambit of the bill has significant implications for the equality protections provided for in the protocol. So if you think it's just about trade and customs, think again. Despite assurances from the government that its new bill ring-fences existing equality protections in the protocol, this is far from the case. The legislation empowers, in fact, ministers to gut many of the elements which underpin Article 2. And in particular, the provisions dealing with dynamic alignment, which require the UK government to keep Northern Ireland up to date with equality obligations in the EU. The Protocol Bill also needs to be seen alongside another important development, which has attracted less attention, but will be of considerable significance in the future. The government's long-awaited review of retained EU law, you remember that was the law that was retained after Brexit, initiated by Lord Frost when he was in government, has resulted in the introduction of the retained EU law revocation and reform bill, currently before Parliament. Like the Protocol Bill, this gives substantial powers to ministers to repeal EU law, retained EU law, which is likely to lead to further deterioration of those rights protections underpinned by such law in Northern Ireland. A dedicated mechanism has, of course, been established to monitor the application in Northern Ireland of, indeed, Article 2, consisting of the Human Rights Commission and the Equality Commission for Northern Ireland, and equipped with powers to bring potential breaches of Article 2 to the attention of the UK and Northern Ireland executive and legislative institutions. And as a result of that, several critical reports have been published, but with only limited success to date in persuading the government to reverse course. A limited exception to date in persuading the government to reverse course was provided when reassurances were given that the UK Internal Market Act would not adversely impact equality protections under the protocol, but that merely demonstrated the potential for it to have done so in the first place. The pursuit of measures that create tensions with the equality protections of the protocol, even after the dedicated mechanism has criticised them, suggests either a very limited awareness of the requirements under Article 2 or a limited commitment on the part of the UK government to abiding by it. There appears to be little consideration of these issues internally in Whitehall departments. Parliamentary committees routinely take expert evidence on these issues and often engage with ministers and members of the House of Lords, in particular raise the implications for human rights in Northern Ireland in debates. But these interventions seldom lead to significant changes in the approach taken by the government. The domestic courts may yet have an important role to play in constraining these developments, but these have yet to be mobilised in many cases. The UK government, I regret to say, appears to be at best negligent, at worst intentionally reckless, as to the adverse effects of its measures, which appear to be driven more by immediate party political concerns than the national interest in protecting the carefully constructed but still fragile peace settlement in Northern Ireland. In practice, the UK government, with a clear parliamentary majority, is able to do what it wants in the equality field, including in Northern Ireland, largely unconstrained by internal constitutional, political, or legal controls. To the extent that the government is likely to be constrained in doing what it wants, this is largely as a result of external political pressures. As a result, appeals to the United States, Ireland, and the EU to exercise what leverage they have to limit adverse changes to equality protections are likely to increase rather than decrease. The Irish government and Irish politicians have taken up various equality and human rights issues in Northern Ireland. The European Commission has met on a number of occasions with groups, including those in this room, supporting human rights and equality, at which their concerns have been clearly articulated, and the Commission is considering its position. The United States Congress and President Biden have been active in identifying the need to protect the operation of the protocol, including its equality protections, as key issues affecting US-UK relations. So the immediate struggle is focused on preventing the gains since 1998 from being eviscerated, rather than building on these gains. That leaves us in something of a dilemma. Up until 2016 and the Brexit referendum, a Single Equality Act was seen by some, not the Equality Commission, by the way, as updating Northern Ireland law to mirror the more progressive parts of the Equalities Act 2010, applying in England, Scotland, and Wales. Such a strategy was not without some risk even at the time. The danger was, of course, that this might lead to new equality legislation for Northern Ireland that took a one-size-fits-all approach, adopting the 2010 British regulatory approach and leaving out or reducing the unique and, as I've said, highly successful fair employment provisions. That remains a concern, by the way. Ensuring that any new legislation, particularly if it emerges in Westminster, preserves these provisions should be a red line in negotiations, a position that I understand, at least I hope, the Equality Commission would support. But in our new political circumstances, pressing for a new Single Equality Act that simply mirrors developments in the UK, should anybody be tempted to go down that line, gives rise to a new problem that reduces the previous problems almost to insignificance. This is because, freed from the progressive requirements of EU equality law, there are now influential voices in GB calling for a wholesale downgrading of GB equality law. This move can be seen most recently in a detailed report by Policy Exchange, a group that has proven quite successful in influencing the current government in other areas. GB equality law may become an increasingly problematic star to follow. What this means is that if, as seems possible, GB equality law increasingly diverges from EU law, the gap between Northern Ireland equality law and GB law will become increasingly wide. And that's because Article 2 of the protocol would prevent changes being introduced in Northern Ireland to the extent that they diverged from EU law. Hence, by the way, the importance of ensuring that the protocol bill does not diminish Article 2. Unfortunately, this may well lead to even greater divergence from the rest of the UK, or at least England. Scotland may well be different. But that is the cost of any strategy in GB that seeks to depart from EU equality law. So you'll be glad to hear I'm finishing. So I began by identifying the important constitutional roles that anti-discrimination law played in the peace process as part of the confidence-building strategy before the 1998 agreement, and in providing a new vision for Northern Ireland in the agreement itself. I end by identifying the important constitutional role that anti-discrimination law continues to play in the peace process in the battle over the protocol. One might say, la lotta continua. The struggle continues. One might also say, plus ça change, plus la même chose. The more things change, the more they stay the same. Thank you.